And that is what caused the confusion, so to speak, here, although I don't think there was any confusion.
The 75 legislation nor the 93 legislation define net premiums written or net premiums collected, did they?
That's correct.
Let's getting back to my question, counsel. How could the 2000 legislature clarify a law that was written in 1975?
They're not clarifying that law. They're clarifying the 93 law. And they're saying that net premiums written does not include the ceded premiums. And again, the cases say that a legislature can clarify the law by adopting a long-standing agency interpretation, you know, when the law is ambiguous, and that is exactly what they did here. The law, it has to have some definition, and what the legislature did was approve that which was used by the agency for all those years.
Mr. Huebner, are you giving up on the issue of brokers' fees?
Not at all. I'd like to go.
Well, I'd like for you to address how Judge Clark's ruling regarding your request to change your answers and to withdraw your admissions could conceivably constitute an abuse of discretion in this case.
Well, the reason it does is because she didn't apply the test correctly. She didn't apply the test at all. And that's an abuse of discretion under the Perez decision, which we filed.
And what part of the test didn't she apply?
She did not apply the first part, which is whether the withdrawal would subserve the litigation of the merits. That is the question she had to decide, and she did not decide that. She focused on the reasons why the agency admitted it in the first place and the reasons why they sought to withdraw it. And she seemed to have the idea, if you look at pages 50, 51 of that transcript, the transcript begins at record page 4831. She had the idea that the admission had to be the result of a technical matter, such as not answering within the time allowed by the rule, whatever.
Now, I had been under the impression that her ruling was based on the proposition that appellees presented evidence to the effect that because the admissions were made, both in the answers and in the request for admissions, they did not pursue discovery regarding documents that had since been destroyed.
No.
That was not the basis of her ruling?
That may have been the basis of her ruling. She didn't say anything in her written order as to why she found prejudice. But that is simply not the case. First of all, what we were trying to withdraw was the admission that they were legally entitled to the deduction, not that the deductions had never been taken, not that employees didn't know about it. They had ample evidence to that effect through depositions and other papers. I think they were given some 6,000 pages of discovery. So Mr. Weatherspoon's affidavit that said, well, I lost some papers when I moved, doesn't prove anything. He didn't really identify what papers he lost. And we weren't denying facts that had occurred. So there's no prejudice there with respect to lost records. Now, the other thing they focused on was the deposition of Mr. Altavilla, who ran the computer system. Mr. Altavilla looked at the period April 2000 to April 2001, when the admission was made, when we sought to withdraw, and he said during that time computer tapes may have been reused or recycled and email may have been deleted. Well, that doesn't have anything to do with the period at issue. The period at issue for which they were seeking recovery was 95 to 98. You know, they had our admissions that deductions of broker's fees and commissions occurred then. They had documents showing that. They had depositions going into that. They took all kinds of depositions on that point.
Were the computer tapes and emails for this period in time destroyed?
That was not clear. Mr. Altavilla said that some of them may have been reused, but it was not clear whether they were or not. I see I'm down to slightly over a minute, so I'd like to reserve the remainder of my time. Thank you.
Volpe.
May it please the Court. My name is Tim Volpe of the law firm of Volpe, Bajalia, Wicks, Rogerson, and Galloway. I have with me at council table my partner, Michael Bajalia. We're here on behalf of the RISCORP appellees. We're co-appellees in this case, along with the Florida Hospitality Mutual. Mr. Page represents that entity. I'm going to argue for 10 minutes. Mr. Page will take the last 5. With due respect to Mr. Huebner, what you've just heard simply has no relationship to the facts that were the record in this case.
Well, why doesn't statute 00-150 answer the question before the Court?
Well, for a number of reasons, Your Honor. To begin with, in order to have retroactive application, that section of the statute has to clearly and unequivocally say that it should be.
Well, all right. Is it your position that that statute does not indicate the desire of the legislature to reach back?
Well, the only thing that can be pointed to in the preface to the statute, not in the statute itself, is this language that suggests that these phrases have meant and shall continue to mean. And so the seizure is upon the words have meant. The statutory provision itself has an effective date. The Supreme Court of Florida has made it crystal clear where there's an effective date in the body of the statute. You need not go around your elbow to get to your thumb with respect to whether or not there's retroactive application of the statute.
Well,
this Court has so held as well.
I wonder if it's just a clarifying statute.
Well, it can't be a clarifying statute under the circumstances here.
Why couldn't the 2001 legislature clarify the term net premiums written in Section 440.49?
Well, for a number of reasons, Your Honor. Number one, it would be a change in the law. The basic premise and the fundamental tenet of statutory interpretation regarding these two taxation statutes that are in issue here is that taxing statutes are to be construed against the government and in favor of the taxpayer.
Well, go back. Why is it a change in the law?
Well, it's a change in the law because prior to the time of this expression by the 2000 legislature, which, as I think Judge Lewis has pointed out, doesn't make a lot of sense to suggest that the 2000 legislature could describe the intent of the legislature in 1993 or in 1975 for that matter.
So your position is that if the legislature in 1975 passes a provision, as the public policymakers in the state of Florida, they pass this provision, the agency interprets the provision the way the legislature thinks it should be interpreted, industry by and large understands that interpretation, complies with that interpretation, and then the general counsel somewhere along the line, in this case in 1997, writes a letter, and there is some confusion for the next year. The legislature then is powerless to come back and clarify what they meant.
They can certainly clarify what they meant going forward. So they can't give effect to some narrower interpretation of a taxing statute that existed. That's the province of the judiciary, not the executive branch.
So a general counsel at an agency can alter public policy just by writing a letter?
Well, I don't think they altered public policy at all, Your Honor.
Well, then why did better than 80% of industry, including RISCORP, pay without deducting ceded premiums if it was so clear?
I'm certainly not at all confident that there's any such thing as a majority in these circumstances. The undisputed testimony in this case is that after the 1993 statute was amended, that is to say to add this phrase net written premium,
did it add
almost
or did it change
immediately. Pardon me?
Did it add that phrase or did it change the phrase?
Well, the phrase was net premium collected prior to 1993 as to both statutes.
Which would imply a lesser amount than net premiums written, wouldn't you think?
No, Your Honor, I wouldn't necessarily describe that. It might indicate a smaller amount. That's certainly not clear from the record. There is no definition that was used in 1975 or 1993. And for that matter, no legislative history, no debate on the floor of the House or the Senate with respect to what was meant at that time.
But isn't it safe to assume that not all policies that are written result in the premiums